When we had lots of breaking and enterings, we had something called a clean slate plea. Most of these were young men, and we would offer them polygraph. We had a polygraph operator on staff, and we would grant them immunity on any other property crimes. Didn't include arson, assault, or sexual assaults. If they cleared up other breaking and enterings, several different occasions in the course of clean slates, we cleared up like 40 B&Es. We'd arrest the other two guys, they do a clean slate, and we don't see that sort of thing anymore, fortunately. And the polygraph is a forgotten.
This right here is fascinating. The judge just described what's basically a clean slate era, a strategy that traded full disclosure for limited immunity. That's old school prosecutorial leverage. But notice the shift. We don't see that sort of thing anymore. Why? Because modern forensic tools, DNA, digital trails, have largely replaced polygraphs as investigative pressure points. So already we're moving from informal problem-solving justice into something far more serious.
Artifact. Um, Good afternoon, Ms. Canfield. Thank you for joining us.
Your Honor, of course.
We're going to return to the matter of People versus John Allen Shook. The file number is 252086. FY. Mr. Shook was charged with criminal sexual conduct in the third degree of an incapacitated victim, 2 counts, as a third habitual offender, making that punishable by, I believe, 30 years in prison. We started a preliminary examination on November 4th. At that time, we took testimony from the complaining witness, Brittany Terry, and Officer Cole Lusby of the Centerville Constant Police Department. Ms. Terry testified about the events of the night in question, which was October 11th, I think. The officer testified. The officer was about to testify regarding statements made by the defendant. The court felt there was a corpus delicti issue.
Okay, pause. Corpus delicti sounds like a medical condition, but legally it means the prosecution must show that a crime actually occurred before the defendant's statements can be used. In other words, you can't convict someone just because they talked. There has to be independent proof. That's a critical safeguard. And in a criminal sexual conduct case, that usually means medical reports, witness testimony, or forensic evidence. The judge is drawing a firm procedural line here.
That there had to be some showing of the elements of the offense before the statements of the defendant could be admitted. The prosecutor had authorized the matter as they felt appropriate, but often in these kind of cases, it takes a while to get everything. So they were waiting for a sane nurse report, sexual assault nurse examiner, SANE, that had been conducted shortly after this on Ms. Terry over in Coldwater, and also waiting for a crime lab report regarding any DNA that they had found. There was an issue regarding the defendant's bond. I did reduce the bond, which probably is a good thing because it's been all the way since November 4th to now to get this reset. I was advised, again, before lunch by Mr. George and Ms. Canfield. They were working on a resolution that would involve a waiver and a potential plea offer in circuit court. Ms. Canfield has handed me an executed waiver. Mr. Shook, here's what it says. I, John Allen Shook, understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one. We have appointed Mr. George. Here's the operative language. I voluntarily waive my right to a preliminary examination and understand that I am bound over to the circuit court on the charges in the complaint and warrant, which would be the 2 existing counts of criminal sexual conduct, 3rd degree, unless we amend it. Is that what you wish to do? Yes. You had to speak your answer.
Yes, Your Honor.
All right. Are we amending this or just simply binding it as the 2 counts that are on it?
Binding it over as is, Your Honor. If there's an amendment, I will do so in circuit court after further negotiations with counsel.
All right. Waived on today's date, which is 2/10/26. Held on 11/4/26 partial. All right, the bond in this matter was altered by me in light of the fact that we had to continue to adjourn it. It was present, it went from 50,000 to 5,000 cash or surety. The defendant has posted it. Is there anything else we need to address regarding the bond?
Just briefly, Your Honor, and I did have the opportunity to speak with Ms. Canfield about this. Ms. Canfield and I have been discussing this over the past few days, the case in general, but more specifically today. My client has been on GPS tether since he bonded at the end of November. I think Your Honor had changed the bond approximately November 18th, and I think he was able to bond shortly after that. It's my understanding that there hasn't been any issue. I've been made aware of any type of issue regarding contact with the complaining witness. My client indicates that having the tether on is causing some physical issues. I think he reported that there's a lot of issues cleaning under that. He had cut himself, and we would just ask whether the court would make a determination about the usefulness of the GPS tether at this point. Obviously, my client would still have a continuing no contact order. If he were found to be in contact in any way, he would be subject to be automatically arrested on that and have his bond canceled. He understands that. I went over that with him today. But, like I said, Your Honor, he has been, from my understanding, compliant. I haven't heard anything regarding any type of issues. We just asked the court to make a determination on the appropriateness of the tether.
Ms. Canfield, what's your thought?
Your Honor, does the court have any conditions with respect to no contact with minors under the age of 18 or people who are sleeping? Anything other than I see no contact with Brittany Terry, but that would be my concern if there's any modification. I do have what I believe to be credible information that the defendant is residing in an apartment where there are at least 7 minor children present at any given time. And that, of course, is a concern for me with the type of allegations that are pending here. Granted, this alleged victim is not a minor, but when I have any sex offender, it is a concern. So I would ask that if this is amended, which at this point I object to, but if it's amended, that it not be any supervised contact with children under the age of 18 or anyone who is on medication or sleeping.
I'm going to leave the bond as it is, Mr. Shook. I took a leap of faith and reduced the bond by a factor of 10. Truth of fact is you're bound over on 2 counts of criminal sexual conduct in the 3rd degree as a habitual offender. We live in a small county. You don't live very far away from where Ms. Terry lives. And I think it's important to have that additional level of supervision. So defendant's request to amend.
That denial is significant. The judge even said he took a leap of faith reducing bond earlier, and now he's balancing public safety with the presumption of innocence. The prosecution raises a new concern: 7 minor children in the residence. That shifts the risk calculation immediately. Here's the big question for you. Is GPS tethering preventative supervision, or does it start to feel like pretrial punishment? Drop your thoughts below.
Bond to lift GPS tether is denied. Now, I don't know what's next. I do know what's next. They set what's called a status conference. And that could be, if you guys are going to work out some sort of plea agreement, it could be set sooner rather than later. But in the regular course of events, it's going to be weeks and weeks before that status conference is set. We're moving. Judge Stutzman has to dismantle his courtroom and reset it up in Three Rivers. He's doing some things remotely. So if we're already crunched, we're going to be more crunched. So it could be May or even later before the status conference is set. If there is an agreement worked out, well, the parties can simply schedule it for something in circuit court. But for the time being, you've posted your bond, you've complied with the conditions of it, and I'm going to leave it as set.
Thank you, Your Honor.
All right, thank you. Angelique, I thought I printed 4 of these, but I only have 3. All right. Good afternoon, sir. You Bradley Wade Chapman?
Yes, sir.
Mr. Chapman, you've got multiple cases. See if I can keep them all straight here. File 292629 alleges criminal sexual conduct in the first degree, second degree, 2 counts in the fourth degree. Criminal sexual conduct first degree is punishable by up to life imprisonment. That's alleged to have occurred on December 16th of 2019. Your attorney in that case is Mr. Arden Mitchell. File 252630 alleges criminal sexual conduct in the first degree, 2 counts, 3 counts, criminal sexual or child abuse in the first degree, 1 count. Your attorney in that case is Arden Mitchell. They're also charged in file 26191 with criminal sexual conduct in the fourth degree. That's punishable by up to 2 years imprisonment or 2 counts of that. And your attorney in that case is Rhonda Ives. That is alleged to have occurred in October of 2025. In file 2616146FY, you're charged with criminal sexual conduct second degree and fourth degree. That's alleged to have occurred between July of 2024 to May of 2025. And your attorney in that case is Rhonda Ives. Everyone has been working hard on this all day and before today. These matters were set for preliminary examination today. I think I told you last week, the preliminary examination is a hearing where it must be established there's probable cause to believe that a crime was committed and probable cause that you did it. You don't get found guilty or not guilty at a preliminary examination. However, generally speaking, it's the prosecutor's policy that if there is a preliminary examination conducted in a criminal sexual conduct case, they revoke a plea offer. And
This is a strategic crossroads moment. In many jurisdictions, once a preliminary exam happens in a CSC case, plea offers vanish. Why? Because the prosecution doesn't want victims testifying twice unless absolutely necessary. So waiving the exam can preserve negotiation leverage. This isn't about guilt, it's about positioning. Defense attorneys are calculating risk versus reward in real time.
that's the way we used to do it. So you got an additional issue. You had Mr. Tim George in one of these cases. He had a conflict. So Rhonda Ives has agreed to take both of those cases, 26191 and 26146. So Ms. Ives has those 2 and Mr. Mitchell has the other 2. Mr. Mitchell, you're at the podium, so I'll defer to you. I see before me 4 waivers of preliminary examination. Is that correct?
That is accurate.
Mr. Chapman, let me go through this like I did with the last guy. You signed each of these. That's your signature on here.
Yes, sir.
And what the waiver language says is I, Bradley Wade Chapman, understand I have a right to employ an attorney. In one case, you've employed an attorney, and in the other 2 cases, we have one appointed. If I may request a court-appointed attorney if I'm financially unable to employ one. Here's the language that matters. I voluntarily waive my right to a preliminary examination and understand that it will be bound over to the circuit court in the charges of the complaint and warrant. And is that what you wish to do in all 4 of these cases?
Yes, sir.
All right. We will not be having a preliminary examination in any of these matters. It does preserve the right for your counsel to pursue.
And that clarification matters. Waiving a preliminary exam is not a confession. It just means the defense isn't forcing the state to prove probable cause at this stage. The real battle shifts to circuit court, where plea negotiations, potential sentencing exposure, and trial strategy loom large. With life max penalties on the table in some of these files, the stakes here couldn't be higher. So now the suspense builds. Will this resolve quietly with a plea, or are we headed toward a full-scale trial?
Plea agreements to perhaps resolve these things. This is not an admission of guilt. It's simply an acceptance that the prosecutor could establish probable cause in each of these charges. I know you've been working on a plea agreement. I don't know, do we need to put it on the record here?
Just one portion of it, Your Honor. I've been speaking with the prosecutor on this case, Ms. Camefield, and we are waiving in exchange for the assurance that